Let's talk about custody. People often confuse the term of custody with placement. Custody refers to decision-making for the children. So when we talk about a custody dispute, the issue becomes who will make the decisions as to school enrollment, which school the children will attend, major medical decisions for the child or children, religious decisions, those type of custody decision-making. There is, in the law, the court will typically presume that it should be joint custody, meaning both parents should be involved in the decision-making, unless there's a reason to give sole decision-making to one parent. Some of the reasons that the court will consider in giving sole decision-making to one parent is if one of the parents has serious psychological issues, if there is a serious issue with alcohol or drugs involved, if there is a criminal history. In those types of cases where there's a concern over one parent, often the court will look and consider sole custody with the other parent and give that person sole decision-making on those important decisions for the child. There are statutory factors that the court must consider when making an order related to custody and placement. Those factors all are enumerated in Wisconsin Chapter 767. Those factors include such things as 1, the wishes of the parents, 2, the wishes of the child. Now, when looking at the wishes of the child, it will be important to consider the age of the child, the maturity level of the child, and the reasons that the child is giving that they want to be with a parent. If that child is giving good reasons, such as this parent cares for me, supervises me properly, provides for me, those are considerations that the court will consider. If a child voices that they want to be with dad because they can stay up all night, or with mom because they can stay up all night, certainly the court would not listen to the wishes of the child in that capacity. Other things the court must look at would be maximizing the time with both parents. There is a new statute in the books right now where the courts in Wisconsin are looking to maximize, meaning as much with each parent as possible. And the considerations that they take into account would be the parent's work schedule. Are the shifts the same? Is somebody working first shift, second shift? How can we coordinate this so that the child is always with a parent and properly supervised? Other factors the court will look at would be the history. Who was the primary parent in the past? They will also look at changes a parent will make in order to be more available to the child. We often see situations where one parent worked a lot and the other parent worked less. When going through the divorce, the parent who worked a lot may say, I want to see my child more now. I'm going through a divorce. I'm going to change my hours. I'm going to cut back on perhaps overtime or extended work because I want to be with my child. And the court will look at that and consider that and try to find out what is the best interest of the child. Ultimately, all of the statutory factors are really focused on best interests of the child. So the court will consider all of the unique dynamics in your situation and focus on what schedule will provide the stability, the structure, and be best for the child so that child prospers and does well in school and moves on and accomplishes the goals that the parents both hope that child can do.